as a former vice chair of the Court of Appeal in Paris, I would like to hear about the legal offering. Thank you.
Merci de m'avoir convié à cette journée.
Thank you for inviting me to this day. I would like to say that the topic I'm going to cover very quickly is both wider yet more restrictive than what you've just announced. Wider because Arjel's litigation comes within a very general frame. We all know here what it means. More fluidity, further developments, networks, interdependence, but also what is fundamental, I find, is the international scope of gambling now. Let me very quickly go over these points, because I find you must all understand the benefits and limits of a national regulation, a European regulation only. And I believe you all understand what I mean behind these words. I don't think I will present the individual protection of our citizens. Well, first, because this is not the main topic. Article 61 of the 2010 law is what you asked me to refer to. But also, I find, and we find it in other sectors, the main difficulty is that the judicial authorities and the courts not only give a sentence on civil cases or penal cases, but consumers can be a player, an economic player, a gambler, a gamer, and have difficulty in knowing which court he has to seize in case of litigation or claim. I don't want to refer either to the criminal side, even though citizens can very well seize this criminal court. I don't want to refer to it, not because I'm not interested by the topic, certainly not. And we have a representative of the higher courts here who might answer any question, but we've had no we've had no case of a penal nature as to civil rights and law. But we do have a number of procedures for illegal operators, as you may imagine, domiciled in interesting regions from a touristic point of view, but not much in terms of enforcing our law. One word on Article 61, whom you all know, I believe, to briefly recall that this is under the current 2010 regulation, as put forward by Europe, or wished from Europe, who in fact asked France to open up the markets to online gambling. Online gambling, from a European perspective and in France, are considered as a specific activity. So the French regulator had to open the market under some conditions, whom you know. You have enforced these conditions. Article 61 of the 2010 law says that the chairman of the online regulation authorities can appeal to the Tribunal of Grande Instance, Court of Appeal of Paris, and I will refer to this position as a referendary council, to obtain not only a condemnation of any illegal gambler or operator who has not received the authorization or agreement or license, but further than that, the judicial authorities must impose some third parties, the suppliers, venturers, must provide the search engines, but sometimes banning an access to some illegal site. This is a provision that has become traditional on the internet sites, and the 2004 law had already anticipated for the banning of some internet sites. And we can understand that the regulator decided that this is a provision which enabled whatever the goodwill from the procedures between illicit site operators, enable them to prevent access to some site, temporarily or definitely, of access to these illegal sites, and this is in fact one of the means used to that effect. This is a provision that had been organized, and the chairman of Arjel has in fact since in 2010 the chairman of the Court of Appeals. We have had since 2010 about 100 procedures, but in fact many more sites than these 100 procedures. A decision or a statement has been taken by the judge in charge of these claims and litigations. And for most of these procedures, except for some of them at the very beginning when the procedure was first used, it did not in fact bring about any remedy, or the remedy in fact was the object of a decision, or no decision had been taken, the judge having decided and that the case law had to be accepted. And maybe this is part of the quality results or report, which we must all look into. It's an interesting case, looking at these case laws. Anyway, many legal questions had been raised, such as the European standards, the remedies. We've had, in fact, some of the justices that were asked for their opinion, and in fact, the debate came to an end very quickly because we saw the problem. As to the judge that has to act in a very specific environment, I would like to note, but this is part of the result, that the regulator has anticipated that possibility of a remedy to the justice to block access to an illegal or illicit site. I, for one, believe that it is a very important step. Well, it is part of the principles of our law, but also in terms of efficacy, efficiency, because we have seen at the courts a number of discussions, legal provisions that are very technical, developing, and it is very, very important to have each element of, in the court, judges and others being able to view their point, whether it's the FAI, the public authorities, the civil courts, all the parties found that having a vision of a general interest and public interest be voiced, so that we could have all these players expressing the legitimate interest, developing their legal means. This is a very good thing. Even if it is time-consuming at the beginning, at last, we now have a conclusive set of decisions. And the Tribunal de Grande Instance de Paris, the Court of Appeal, organized specific hearings on the topic within very good conditions, high-level discussions. In other terms, we now have these various players mentioned, including the judge and the lawyers representing the various parties of the sectors, exchanging, getting to know each other, evolving in their thoughts and discussions in the light of what their counterparts could inform them about. This is what the case law, in fact, is all about. And this is how part of the role of the justice or the judge, which is not only to apply the law, but also to listen and enable a better development of the law. This is what, therefore, the role is. I mentioned this 2010 law, which is very important, but we also have the difficulties of implementing a law. In his or her wisdom, in the new cases, the judge can now be seized based on the procedure as a remedy, in the same line as a remedy, which is now the only possible action for the procedures to be judged rapidly. And what we should now remember is the decision is that of substance, and the remedy, in fact, looks at the procedure and looks at the oral procedure. As you know, remedies represent an oral procedure. How shall I put it? Well, you may challenge, in fact, the conclusions of the lawyers before you have 60 pages in writing. There is something in writing, obviously, but we have an oral procedure, verbal procedure. With the discussions, we still have that element of procedure in writing. On a litigation due to an internet action, the oral means are described without communicating, in fact, with the jurisdiction concerned, which makes the life more complex. But I believe the solution is going to be found to this part of the procedure of the remedies. At the end of the remedies procedure, there is one advantage, which is that of an oral procedure until the hearing stage, where the requests of each party may very well evolve, which is interesting. In the case of a claim, a litigation, so that the host, in fact, claimant can select right at the end of the procedure to change something. So, in fact, implementing this law raises another problem, which is the possibility for Arjel to modify its request before the hearing, whenever possible. And the question again is how to challenge the various host sides, which are the object of all the observations in the claim. The power of the judge in this remedy procedure is interesting because the judges take adequate measures, i.e. they have to satisfy a situation or provide answers to a situation, but they still do have a given margin of maneuver whenever the political situation may evolve. Then this is all very interesting when it comes to selecting a procedure. Fine, I'd like to briefly discuss problems of costs and well, the costs are, in fact, on the shoulders, so to speak, of the President of Arjel. And if the FAIs or suppliers wish to see the French law applied, I will say all the hosts, in fact, are domiciled in other countries, in countries that are what we call exotic countries, or maybe less exotic, but with little aim of cooperating. This is it's another major element of the law. Arjel may very well assign a host site domiciliated in Costa Rica, for instance. I was going to say in Zimbabwe, but no, not in Zimbabwe. We had one case in Australia, and a major one, and it's a country of law and order, but still, we have countries like Curaçao, Malta, and other islands. Malta is a European country, European member state, which poses a number of such problems. For those of us who may, in fact, convey the procedures, we find we have a lot of difficulties in understanding even the translation that they provide to us. Now, the procedure is also related to the length of execution. And again, we have the same difficulty in voicing a sentence as we have in assigning, in fact, the offenders. President of Arjel will confirm that we never have to try a decision on illicit hosts executed by an executory procedure. Let me then say a few words on how these claims may evolve for the host side, which is a difficulty we have come across. Well, the moment the sentence is given, all these elements, the site determination, etc., are given,
désarmés face à cette situation. Alors, il y a quelques
And in fact, sometimes we have a very difficult situation where there is a lack of clarity. There is another possible solution. The first one would be
la saisine du juge qui a déjà statué sur un
allow,
site
in fact,
de manière plus simple,
a
par exemple,
judge who has already given a
lors que
sentence
l'un
on
des
a
éléments,
more
par
simple but
exemple,
similar case,
où
render his sentence when
a
one
changé.
of the elements
Puis, il faut dire
has
un
changed,
mot de
either
la-
name
d'une
of
des
the
discussions qui a
site
eu-
or any other. I must say that one of
présentée
the
devant le juge
elements of
plus tard,
discussions
il est un petit peu
presented
moins,
to
mais
the
quand même,
justice or to the judge
c'est la
judge
situation dite de la chronologie des
is
procédures. C'est-à-dire que le législateur, dès 2004,
that of the
d'ailleurs,
time
avait eu cette,
sequence of the procedures
ce sentiment
since
qu'il fallait,
2004, the regulator
s'attaquer, entre guillemets, en tous les cas, s'occuper
already
d'abord
had the
de
sentiment
l'opérateur,
that
puis ensuite de l'hébergeur, et
they
enfin,
had to look into the
du
operator's case
fournisseur
first,
d'accès à
then
Internet, qui est évidemment est
the
peut-être le moins
access
efficace et
provider,
surtout le moins concerné par
and
la CIT, mais en tous les cas,
the one who was in fact
cette
less
démarche
concerned,
qui était présentée comme logique et
maybe.
que
So
certains
this is an
ont
approach
dû
that seemed to be
soutenir,
rational at that
sous la
time,
forme de ce qui a
and
été appelé
some
le principe de
supported in fact
subsidiarité. Cette démarche, d'abord,
the
n'est pas
principle
prévue
of
par,
subsidiarity. So this is an approach which
français,
is not in
c'est très
fact
bien.
foreseen
Ça n'est pas non plus
in
dans
France,
les normes
in this
européennes, mais
case,
surtout, c'est tout à
nor
fait
is it
contraire à
planned by the
l'efficacité et
nor is
à
it
la
anticipated
réalité.
by the European
Car,
standards, and it goes
l'hébergeur,
against the
comme
efficiency
chacun
and
peut comprendre,
the
est celui qui
pragmatic
est choisi par l'opérateur.
aspect of
D'ailleurs,
it,
ça,
because
parfois, l'opérateur
hosts,
est lui-même son hébergeur.
in
Ce
fact, are
signifie que,
selected by the
si
operators,
on
and sometimes
discute de
operators can be the hosts
l'évolution,
themselves.
de la
So
loi,
if
dans
we
le
start
sens,
discussing
d'une meilleure efficacité, et si
the
on veut
law
éviter une fraude à la
in
loi
the sense of
systématique
efficiency,
qui
efficacy,
concerne,
and
la
if you want
présence
to
de
avoid a
ces
systematic
intermédiaires-là,
frauds
il faut
too
dire
low,
très simplement que le président
well, these
Arjel
intermediaries or third parties
saisir le président
must very much be controlled, and Arjel can
Arjel
very well ask the chairman of the Court of Appeal in France to open a case against any intermediary, any offender,
moteur de recherche, pourquoi pas,
whether an internet access provider, search engine, as has been the case, or
selon son choix. Voilà. Alors, dernier
host
élément
at
que
his
je voudrais souligner,
pleasure.
peut-être,
The last
c'est que,
element I would like
en
to
effet,
cover,
dans le cadre de l'article 61, bien sûr, le juge judiciaire n'est pas
Article
compétent
61,
pour
I keep referring to the Article
sur
61,
les
the judicial
demandes
authorities aren't competent to
personnes, c'est-à-dire des consommateurs,
decide
éventuellement,
on
victimes
individual requests, i.e. for
malveillance.
consumers, clients who
En
might be
revanche,
a victim
on peut
of an
s'interroger
offense
sur justement ces procédures, soit
or
civiles,
of
soit
swindlers.
pénales,
Now we might very
qui
well
pourraient peut-être faire
question
l'objet
these
d'un
criminal or
réexamen,
civil
car, je pense que
cases,
c'est
which might be
inimaginable
reviewed.
de penser-
Indeed,
de
we find
de
it
retenir
difficult to
qu'il n'y a pas de
imagine
litige aujourd'hui et depuis 5 ans
that there can be no claim,
consommateurs,
as has been the case over the
et,
last 5 years,
c'est
between
les opérateurs,
consumers,
surtout s'ils
a
sont
gambler,
illégaux. Donc c'est
a
un
better,
champ de réflexion,
and
je crois, qu'il
operators,
faut
especially
Quant au rôle
illicit
de l'Arjel,
operators. So this is
d'autres,
something for further
l'ont
review.
abordé. Je pense
As to the role of
effectivement qu'il y
Arjel,
a,
others have already covered this item, and
pistes
yes,
à
I believe
creuser. Éventuellement,
there are
l'ancien
interesting
magistrat que je
avenues to
suis
discuss.
pourrait, donner,
And
quelques
as a
éléments de
former
réflexion
magistrate,
supplémentaires. Mais mon
I
temps
have
est
tried to give you some
largement
elements
épuisé,
of
donc je vous prie de m'en
thinking, and I
excuser et
believe
je vous
I've been
remercie.
much too talkative. I do apologize. Thank you very much.
Merci beaucoup.